Are you being sued by a collection agency, or have you just received a summons to appear in court? Well, let me show you how you can respond so that you can potentially get the court case against you dismissed. Let's hop right in. What's up, party people? It's me, Jazzy Mac. Thank you so much for being here. Do me a favor. If you are not new to my channel, make sure that you have liked this video and that you've hit the subscribe button so that you can be notified for all of the new stuff that I have coming out. I have a ton of stuff planned, so you don't want to miss this. And if you're new to my channel, hello, welcome in. It's so nice to have you here. I am going to ask you to also like and subscribe to this video so that we can stay connected and so that you can improve your credit score. I'm passionate about this. Listen, the people that have used my templates, I am just so happy that people are reporting that they've seen a 121 point increase, like Miss Angelica. Tyler got a $3,400 collection removed. Oh my goodness. Just so many other stories, testimonies of people using my templates to get collections removed. But you may be saying, well, Jazzy, my situation is different. Like I've been served. I'm about to be sued. So there's a different path that you would take if you are being sued. Now, in the follow-up video to this, I will be talking through step by step, a part of the answer that you have to give in response to being summoned to court, but I just want to go over the basics. So here's the thing. People think that if they receive a summons, they think that if they don't answer the door, or they think that if the sheriff doesn't physically put something in their hand, that they don't have to go to court or that it's invalid. People, I'm here to tell you that that is a myth. That's something that you see on TV. If someone is summoning, if you get summoned to court, that is still legally enforceable, whether you are at home, whether you're at work, whether you don't sign for it, whether you don't answer the door and they just leave it in the mailbox. It is 100% enforceable. And the reason why people get judgments against them when they're sued by a collection agency is purely because they don't show up to court. The judge ends up entering a default judgment. Now, of course, I want to preface this video by saying I am not an attorney. All I can do is speak from personal experience. Your girl has spent, some time in some courtrooms for all types of stuff. And I have been victorious in every situation. So I want to share that with you because I don't want you to be afraid of court. Court is nothing to fear. In fact, when you go to court, judges are typically more sympathetic with people that show up to court because it shows that you're interested in resolving the situation. A judge is not going to be sympathetic with you if you just don't show up. So you have to show up. That increases your chances of getting it dismissed. So the first thing that you want to do is don't panic. If you get served a summons, cool, that's fine. It happens. It doesn't mean that you're guilty of anything. It doesn't even mean that the other side is going to show up. It just means you've been served. So don't panic. The next thing that I want you to prepare to do is to draft an answer. An answer is basically just your response to the summons. The summons should essentially map out or outline what the law firm is alleging you've done as it relates to the debt collection. So they're probably going to have something that maps out your name, your address, and it's going to say that, you've defaulted on something, and it's probably going to also list out the account number, and then it's going to probably also list out the amount that they're saying that you defaulted on. So it's probably going to be 3 or 4 different allegations or sections where they're alleging that you have done something or not done something. And so you have to respond to that. So I want you to, for one, you're going to draft an answer. And that answer is going to be your response that you're going to file in your local court, whatever the court is that's listed on the summons. So you're probably going to have to file it with the clerk. And depending on what part of the country you're in, it might be $10 to file it. It might be $25. The prices vary depending on the court. But you'll want to pay that filing fee because that's how you get your response officially recorded. And so what you're going to do with this response is you're going to respond to each section that they're alleging. And it's not going to be like a whole bunch of like a super long paragraph of legal jargon that you can't understand. Most of it should be understandable, but obviously if you don't understand, you can contact an attorney to help you sift through the verbiage. So you want to acknowledge that the debt is yours or that it's not. What you do not want to do is lie flat out and say that, if this is for like, let's say that you owe MasterCard. They're suing you for a charge off. Now, if you know that you've actually had a MasterCard and that the account number that they list out is your actual account number, don't go in and say this is identity theft. Don't respond by saying that the account doesn't belong to you. Because again, the methods for court summons are totally different. So you don't want to incriminate yourself by lying and saying, even though there's this, information that it belongs to you, you don't want to deny something that is easily verifiable. So you want to acknowledge, if the debt is legitimate, if it belongs to you, you'll acknowledge that, you'll acknowledge the account number. But then there may be an amount listed. And that amount could be questionable. In your head, you might have remembered only owing MasterCard $500. But in the summons, they may have alleged that you now owe $6,000. And you're thinking, well, 500 and 6,000 are nowhere near each other. So I am going to deny owing this amount, or you can state that you are questioning the evidence, or that you're requesting proof that you owe that amount. So you're still being truthful, but you're also saying, listen, that's not what I remember. I remember 500. You're claiming 6,000. So I'm going to need to see proof of that. So essentially through your answer that you're filing with the clerk at the court, you're asking them for proof in your answer. Now they are going to, once they file your answer, they won't send it out. They just file it. You'll want to get 2 copies. You'll want to keep a copy for your records, and then make sure that the clerk stamps it and puts a timestamp on it, because you'll want to take a copy of that signed and stamped answer, and you'll want to send that to whatever law firm is attempting to sue you. So once that is done, you'll wait for your court date. And once it comes time for you to go to court, you want to appear, and the judge is going to ask you what happened. And, and again, in the answer, keep it short and simple. Don't put your whole life story on there, or you want to keep it very short and simple. They don't need a backstory. They just need to know if you acknowledge it, if it's yours, and if you agree with the amount of the debt. So that's what needs to go in your answer. Now, once you get to court, then you can explain your side and say, I wasn't aware that, the debt was 6,000. I was under the impression that it was 500. I would really like to see proof from them. Trust me, there are companies that literally buy old debts. There are law firms that take people to court all day and they win it because people don't know their rights. People don't know that they have the right to request that they validate what they're saying that you owe. So sometimes you may go to court and you'll say, hey, I need to see proof that I owe $6,000 because that's not accurate according to my recollection. And then when that happens, the judge may ultimately dismiss it if the other person doesn't show up, or if they think that the person is charging you an erroneous amount, they could dismiss it, or they could just set another court date and say, okay, I'm going to give you 14 days to come up with this information that proves that they owe $6,000. And if you can't come up with it, the case is dismissed. I have seen so many cases get dismissed just off of that. So you want to make sure in your answer, that's why you want to acknowledge that, yeah, I remember having this account. The account information is correct, but the balance is not. And I need that validated. So I hope this was helpful for you. Please let me know. There are just companies out there that just really try to cash in on hardworking people. And I'm not going to let that happen. I don't like that happening to the people I care about. We're besties, okay? And I look out for my besties. So please make sure you keep me posted on, if this has ever happened to you or where you are in the journey. And again, if you, have specific legal questions about things in your state, make sure that you speak to a consumer attorney so that you can get those things cleared up. I will see you all in the next video. Stay safe and stay awesome. Toodles!